Hello, good day. My name is Karen Wilson Robinson. I'm an attorney licensed to practice in New York, New Jersey, and currently working on my qualifications to practice in Jamaica. And I'm excited to be here. My area of practice covers intellectual property. What is intellectual property? A lot of people ask that question. What does that mean? Well, intellectual property deals with your the creativity of your mind. It covers what you have conceived, what you've reduced to a writing or a product. It is what you've come up with, not an idea, but an actual documented product or service or something that you've come up with that is yours, all yours. You have to be the one who have created it. It has to be your idea that's been reduced to a writing, but it's something that you created. And it covers three main areas. I'll start first with a patent. A patent covers a product that you've created, that you've invented. So it covers that product. A trademark covers your brand. It is the name, your logo, whatever it is that you use to identify your goods and services. That's what a trademark covers. And of course, you have the copyright. The copyright protects your original music, original artistic or literary work, right? Well, let me give you an example of how they all intertwine. Say, for example, that you invented a vacuum cleaner. You would need a patent to protect the design and the invention of the vacuum, right? You would then need a trademark to register your name or logo, whatever you call it. If you call it Karen's Vacuum, well, that's a little bit generic. But if you come up with something creative, Shark is, that's the name that identifies that vacuum cleaner, and that would get a trademark protection. If you were to have a logo associated with that, that would be your trademark protection. Then, if you created a commercial, a jingle, something that you used to advertise and promote that vacuum, that would get copyright protection. So that's how all three of them are intertwined. Oftentimes I hear people say, "Oh, I have something here and I think I need a copyright." And when I sit down and I go through what it is that they have, then I can identify that it's either a patent protection that's being sought, trademark, or in fact, it is a copyright that they need. Most of you here today are creative, so your focus may be in the copyright arena. The copyright protects original works of authorship. That includes literary works, that dramatic, musical, artistic work such as your poetry, novels, music, songs. What it doesn't protect is facts, ideas, systems, methods of operations. Although it may protect how those things are expressed, it doesn't exactly protect those. We are increasingly in a digital space. So, you can seek to do copyright registration for original authorship appearing on a website. So if you've created your website that, you have taken the photos that you're utilizing, you have drawn, you have designed, it's your work. It's not something that you pulled off of the internet that you're embedding in your website, something that you yourself created, then you could possibly get protection for that. And I know a lot of people are on Instagram, so you're like, can I register my Instagram? Well, you can copyright the photos that you take, that you place on Instagram, your photos, your music that you're using as for the reels or whatever they call them. You can use those, your original work, your original authorship. Those things can be protected. And a lot of what I encounter in my practice are folks who have created something many years ago, never thought to do any protection. And now they're in a situation where they're looking to see what they can do. Now, why? Why is that? Because we don't think about that. Oftentimes we're so happy with what we're doing. We're so happy with that song that we've written. We're so happy with the sound recording that we've created, the poetry that we wrote, that we don't stop to think about, how do I monetize this? How do I make money from what I've done? I encounter artists that, they get in the studio, they bang out this song, and then they get to the point where it's being given airplay, it's being distributed. And then they start asking the questions, but wait, how do I get paid? You don't understand the music and the business end of your creativity. And that's when people end up coming to me, because now you're in a situation where you are not receiving monies from what you've created. And I mean, who wants to sit down and come up with this brilliant idea and then you're not able to monetize that? You're not able to see the fruits of your labor. A lot of what we do is because we want to be able to pay our bills, right? We want to be able to eat. We want to be able to take care of our families. So when you come up with these ideas, when you have written that, those lyrics and they become this hit song, when you have created this great poem that's being utilized in, graduations or whatever they may be used, you want to be able to protect it before you release it out into the public domain, before you share it, even with your friends and families. You want to seek those protections to ensure that once it goes out there, you have control. Because if you put it out there and you already have the protections, you're better able then to negotiate with the folks who may have what we call infringed on it. If they're using it without your permission, you're better able to go after them if they have benefited from it by they're the ones out there making the money and not you. We're able to go and collect from them for what rightfully should be yours. A lot of times folks wait until they have shared it widely. And again, we're in this digital space where anything that you put out there, it's gone. Before you know it, is shared far and wide, and you lose that control. And then when someone comes to you now, or when you hear it, if you hear your song or you hear some of your lyrics in somebody else's song, and when you come now saying, what can I do? We now have to go and recreate what you've done. And oftentimes that's difficult, right? Because there's only so many discrete ideas out there, and people can come up with things independently. The burden is on you to show you were the one who created it. You were the one who come up with it first. And oftentimes that could be difficult because sometimes you're in that moment when you create something that you never captured how you got there. You didn't capture the steps you took to come up with the lyrics to your song. You never captured the steps you took to invent that product. You never captured the steps you took to come up with that unique name that you're using in association with your business, with your identity. If you're not using your own name as an artist, if you have this unique name, so before you put yourself in a position where someone else has now used what you believe is your work, you are the author, you did this, before someone else is benefiting from that, to avoid all of the headaches down the road, is strongly advised that once you have come up with a thought, once you've come up with those ideas and you've written them down and you have created, in the case of a product, a patent, or if you have the lyrics to a song, your poem, musical works, a sound recording, instrumental, whatever it is that you've come up with, before you share it, you get those protections, whether it be the patent, whether it be the trademark, whether it be the copyright. You want to know that you have adequately protected yourself, that you have adequately done the steps you need to take. So if someone in the future takes what you have, you can go after them legally. And just so you know, a lot of people think, well, if I write it down and I have that, I'll do what they call the poor man's copyright. Well, the laws here in the United States have changed where you have to have a registered copyright in order for you to go after someone who's using your work. And if you have to do it quickly because you have a discrete time in which to go after them, then you will have to expedite your application. And I like to tell folks, it's a lot less expensive to protect your work upfront than it is to now fight someone who has stolen and is using your work without your permission. So again, I'm an intellectual property attorney and I handle the patents, the trademarks, the copyrights, and I strongly encourage you to protect your work of authorship before you share it with the public. I'm happy to be here again. I hope you have a great symposium. If you have any questions, feel free to contact me. I'm happy to answer your questions. Have a wonderful symposium. Bye-bye.